Hi, my name is Chris Addick. I'm with the Veterans Law Blog. You can find us at veteranslawblog.org. Today's video blog entry is going to answer one of the most commonly asked VA questions. I'm going to get to that in a minute, but I want to do a special thank you to a group that's really helping to get the word out to veterans battling the VA. I'm here today on hadit.com. I want to give a special thank you to the folks here at hadit.com who invited me to guest post on their blog. I look forward to regularly contributing to the hadit.com blog a few times each month, both through video posts and through written blog posts. A special shout out to Teresa, y'all probably know her as T-Bird, who has given me a list of questions about the VA claims process that many veterans just can't find the answers to. So today I want to talk to you about a question that a lot of veterans ask me, and I haven't been able to find the answer online. That question is, if I get a 100% rating, should I keep fighting the VA for more service-connected disability benefits? Let's jump right into the answer. A lot of veterans, most veterans, perceive the 100% rating as the end of the line, the sign of victory over the VA hamster wheel. In fact, when a veteran tells me that they use my blog, books, or some of my training videos to win their own VA claim, I envision them celebrating their victory over the VA's red tape machine by running up those famous Rocky steps at the Philadelphia Museum of Art. Now, if you don't know what I'm talking about, you need to go watch the movie Rocky. One of the classics, one of the most inspirational scenes of all time is when Rocky runs up those famous Rocky steps. But anyway, I digress a little bit. Is it really over when you get to a 100% service-connected rating? Well, for sure the hard part is, but I think there's at least 6 reasons that you might want to consider continuing the battle against the VA even after you reach 100%. Of course, it's a very personal decision. I'm not advising you to do that. This isn't legal advice. And I just want to give you enough information so that you can understand how to make that decision for yourself. So let's talk about 6 scenarios that I've seen where a veteran might want to continue fighting the VA even after they've reached the 100% ratings mark. So, first of all, if your 100% rating is based on TDIU, then it may not be permanent and you may want to keep fighting. What does that mean? There's several paths to a 100% rating in VA compensation. One of the most common is the TDIU claim. Now, the court has told us it doesn't want us calling these TDIU claims, but I'm not before the court right now. I'm talking in layman's language. I'm talking with my fellow veterans. So a TDIU claim is what we call it. Those of you that don't know what TDIU is, it's a claim for benefits based on total disability individual unemployability. Essentially, it says that you get a 100% rating when your service-connected disability or a combination of service-connected disabilities render you unable to procure substantially gainful activity in an employment situation. Now, those are all legal terms of art that are far too complex and detailed for this post. You can read all about TDIU here on hadit.com. You can go to the Veterans Law Blog and read about TDIU. I've even written a book on TDIU if you're so inclined to read an ebook that helps you prove and develop your TDIU claim. But when a veteran's awarded TDIU, there's absolutely no guarantee that it's going to last forever. In fact, if you don't submit that annual income statement showing that your income is still below that federal poverty line limit, or if the VA gets some evidence that you have engaged in substantially gainful activity or employment, most commonly from the IRS or Social Security, then the VA could reduce your rating to the combined rating that was in place prior to the TDIU grant. So it's almost always preferable to have a scheduler 100% rating, meaning that your 100% rating is based on the schedule of impairment ratings for disabilities and not on the circumstances of your employment. So even if you get approved for 100% based on TDIU, you might want to give serious consideration to continuing to pursue service-connected ratings until your scheduler rating reaches 100%. Scheduler ratings become protected at certain points. And again, that's too much detail for this post, but what you should know is that there are times when the VA can no longer lawfully reduce a 100% scheduler rating. And I talk about those over on the Veterans Law Blog. You can chat with excuse me, a little tongue-tied there. You can chat with other veterans here on hadit.com and understand what those protection levels are when the VA can no longer reduce your 100% rating. This advice that I'm suggesting here, or this thought process that I'm suggesting here, is contrary to what many VSOs are going to tell you. they're going to tell veterans not to rock the boat. When you get 100% based on TDIU, withdraw all your appeals so that the VA doesn't think you're rocking the boat or trying to get more than you're entitled to. They tell you to stop fighting, take the TDIU, count your blessings that you got to 100%. And in my experience, I think this is a fairy tale. VSOs tell it to veterans all the time. Unfortunately, a couple of attorneys suggest it to veterans. And a lot of times the VSO or sometimes an attorney will horse trade the rest of your appeals in order to get the VA to assign a TDIU rating. Now, I'm not saying anybody's doing anything wrong. The VA doesn't grant benefits, as you all know, unless you can really prove the legal entitlement to them. But what happens is they, a lot of times, will use that TDIU decision to cut off any other appeals. And if I've seen it once, I've seen it 100 times. The VA calls up a veteran and says, hey, we're going to go ahead and grant you this TDIU. We just want you to put it in writing that you're withdrawing your other appeals. Well, the veteran thinks those two things are connected, so they sign and they agree to withdraw their other appeal conditions, and they lose out on a lot of past due benefits and some other benefits that I'm going to talk to you about in the rest of this video. So if you get a 100% TDIU rating, you might want to consider continuing to fight the VA until your scheduler ratings reach 100%. All right, now we're going to jump into the second reason that you might want to consider continuing the fight against the VA even after you've gotten a 100% rating. And that scenario occurs when you did not get the right effective date for your 100% rating. So let's wind the clock back a little bit here. When I talk to veterans about how they should generally approach an appeal for a denied service connection claim, here's the order of battle that I teach them to follow. First, get as many of your medical conditions service connected as you can. Once your medical conditions are service connected, then what I want you to consider doing is fighting to make sure that they assign the correct impairment rating, and at the same time fight for the earliest effective date possible. Now, what is an effective date? An effective date basically is the date from which the VA will start paying you your past due benefits. So let's say you file a claim in 2010, the VA doesn't grant it until 2015. If they assign the effective date as the date of your 2010 claim, they're going to pay you past due benefits all the way back to 2010. So if they decide that 2014 is your effective date, though, for whatever reason, then you're only going to get paid past due benefits back to 2014. So it's very important that you get the effective date correct. Unfortunately, many times when the VA grants a 100% rating, whether it's TDIU or a scheduler or 100% or any of the other types of 100% ratings, they don't always, in fact, very frequently, they do not give you the correct effective date. And at 100%, those past due benefits can really start adding up. So using the 2014 disability rates, those ones that came into effect in December of last year, a single veteran loses out on $2,906.83 for every month that the VA miscalculates the effective date. Let's say that single veteran with no spouse, no children, misses the effective date by 1 year. That means that the VA is going to short them $34,881.96. What if it's 5 years? Multiply that by 5. If it's 10 years. My point is this. Just because the VA got your rating to 100% doesn't mean that they gave you the right effective date. And if they gave you the wrong effective date, you could be losing out on a lot of past due benefits. So when you get that 100% rating, if you don't think they assigned you the correct effective date, you're going to want to consider whether or not to appeal that decision. Even though you got 100%, you're going to want to consider whether or not you should appeal that effective date to get an earlier date and thus more past due benefits. So the third time that you might want to consider continuing to fight the VA or to battle the VA even after getting a 100% rating is in the scenario called special monthly compensation. So now, not many veterans have ever heard of special monthly comp. And so because they haven't heard of it, many veterans don't pursue it when they get their 100% rating. To be quite honest, a lot of VA raters and a lot of VSOs haven't even heard of or know how to correctly compute special monthly compensation, or SMC. SMC is really, really complicated, but generally it works like this. When a veteran receives a 100% rating, the VA is supposed to consider whether they might be eligible for additional monthly payments known as SMC, or special monthly comp. So I've seen some posts out there and I've seen some information out there. In fact, some PowerPoint slides from one VSO that calls it special medical compensation. Obviously, that's the wrong terminology. And that should be a real, flashing red light saying don't work with a VSO or an accredited representative agent or attorney that doesn't know the right jargon. If they don't know the jargon, chances are they don't know the law. But in any event, there's many, many, many different kinds of special monthly compensation. And so I don't want you to think that just because I'm telling you about a couple in this video here, that that's all there is. There's a lot. And in fact, I recommend that if you have questions about special monthly compensation, that you do seek out legal advice from an accredited VA attorney. That way you make sure that you're getting the straight scoop on SMC. There's often a lot more available, certainly a lot more available than what I talk about in this video. One of the more common kinds of SMC that the VA overlooks when they assign a 100% rating is called statutory SMC. Some folks call it statutory housebound. Largely, it's what's called SMCS. And basically, that means that one of two situations has to occur in order for you to get this special monthly compensation. One of them is statutory. The other is housebound. So if you're housebound because of your service-connected disability benefits, and that term has a special definition in the regulations, then you're entitled to get this extra monthly compensation. Additionally, if you are statutorily eligible, in other words, if you have a 100% rating for one condition and a 60% rating for or higher for a separate condition, an unrelated condition, you're also entitled to this same SMCS. So there's two ways that you can get it, statutory or housebound. Hence statutory housebound. But in any event, it's $347 a month in extra VA disability benefits going by the tables from December 1st of 2014. It typically increases each year as the disability ratings increase, the special monthly comp amounts increase as well. So check your most current rating table to make sure that you have the correct amount for SMCS. If you're watching this video in 2016, that amount is probably a little bit higher right now. But you're also eligible for loss or loss of use of extremity special monthly comp for loss or loss of use of sensory organs or reproductive organs, whole host of different scenarios. Sometimes these things add together. There's aid and attendance, there's enhanced aid and attendance. When you have certain types of special monthly comp that merge together, you're entitled to another level. There's half steps of special monthly comp. It gets really complicated, and I do not mean to get into all that here. I don't want to overwhelm you. What I want you to take away from this, though, is that when you get that 100% rating, you may be entitled to special monthly compensation. And if you are, or think you are, you're going to want to continue the fight against the VA for those benefits. Just so you know, and you got to be in pretty bad shape to get to the highest levels of special monthly comp. I've seen a couple veterans, and typically they're almost always quadriplegic, bedbound, and hospitalized, but they can reach up to $8,850 or so for a single vet with no children each month. But again, those veterans are in really, really, really bad shape. They're in the worst medical condition of any of us. But I've still seen the VA stiff a lot of veterans who are just housebound, who are bedbound, who just might be solely quadriplegic and not have any other limitations, but they stiff them out of that special monthly compensation simply because the veterans stop fighting for those benefits when they reached 100%. A lot of times veterans think that 100% is the highest level you can get. It's not. You can look at special monthly compensation to take you even higher than that 100% rating. So that's the third time you might want to consider continuing the fight against the VA even after reaching a 100% rating. All right, we're halfway there, folks. This is the fourth time that you might want to consider continuing the battle against the VA even after reaching a 100% rating. And that situation is going to be what I call protecting yourself against future reduction proposals by the VA. So we all know that the VA loves to reduce benefits, often for no reason at all. Most times that I've seen them reduce it, it's been an unlawful reduction, either because they're not allowed to reduce the benefits or because they violated some due process requirement prior to reducing the veteran's benefits. But there's not a week that goes by that I don't talk to at least one vet who is rated 100%, typically scheduler, and then the VA comes out of nowhere and reduces them to 0% or 10%. A lot of times when I dig into the C file or the claims file for these veterans, I find other conditions that were improperly rated in the past, or that the veteran gave up on when they reached their first 100% rating. Had those conditions been properly rated in the past, the veteran might not have seen any reduction in disability compensation when the VA reduced the rating on another condition. Kind of goes hand in hand with what I talked about a moment ago, that just because you reach 100% on one condition doesn't mean you shouldn't continue to pursue the highest ratings on other conditions. That way, if the VA reduces any one of them, you might have enough service-connected ratings to keep your overall impairment rating from being reduced. Let me give you an example. I saw this one a couple years ago. So we've got a veteran. He was presumed exposed to Agent Orange, and he had both ischemic heart disease and prostate cancer. Both conditions were severe enough that the veteran should have been rated at 100% for each condition. However, a VSO gave him some really bad advice, and the veteran gave up his claims and appeals for the heart and cancer conditions after the VA awarded TDIU for the veteran's back condition. Okay? So there's three conditions: the back, the heart, and the cancer, the prostate cancer condition. And the VA granted him 100% TDIU because of his back. He couldn't work, but he gave up his claims and appeals for the heart and cancer claims that probably should have been at 100%. So a couple years later, the veteran reported some income to the IRS from a side project that he was working on. It wasn't a lot of income, but it was enough to show that the veteran was able to participate in substantially gainful activity even with his disabling back condition. So the VA cut his 100% TDIU rating. They cut it back down to 60%, which is where it was before the TDIU 100%. So had the veteran ignored that VSO's don't rock the boat advice, had he continued his heart and prostate cancer claims, he would have been independently rated at 100% for two other conditions, and the issue of TDIU would never have come up. Because remember, if you're rated 100% on a scheduler rating, you can work a full-time job. You could make $1 million a minute, and the VA cannot reduce your 100% scheduler rating based on income. The only time they can reduce you on a 100% rating based on how much money you make is when you're getting a 100% TDIU rating. So anyway, in the case of that veteran I just told you, we fixed the situation. It took a couple of years, but during that time the veteran faced some pretty significant financial problems because of the reduction of his VA disability benefits from 100% back down to 60%. That's a pretty significant reduction, and it's a pretty significant reduction for an older veteran who is on a very strict budget because they're on a very, month to month from either their Social Security or their VA disability. It's hard when you lose almost half of that money because the VA decided to reduce the benefits. So what I want you to take away from this is the following. Get service connected for any condition that you believe is related to your military service, regardless how high your current total impairment rating is. If you have claims out there that are not service connected, when you get to 100% on a scheduler basis or a TDIU basis for any other claims, continue the fight because you may need those higher ratings later if the VA wants to try to reduce your 100% rating. By the way, I'm working on an ebook right now that I'm going to teach veterans how to defend against a VA ratings reduction. So I'm going to put a link up on the screen right here so that you can sign up for an email announcement when that ebook is ready for release. So just click on that link, go there, put your email address in and name, and I'll send you out an email and let you know when that ebook is ready to be published. So let's talk about the fifth time that you might want to consider continuing the fight against the VA even after getting a 100% disability rating. So it's the rare veteran that's pursuing service connection for just one condition. That's really, really rare. When a veteran gets to 100% on one condition, a lot of VSOs and a lot of other vets, and frankly some attorneys out there, are going to say that the veteran should just give up their other claims and appeals. They say don't rock the boat. So I'm going to tell you another story about a veteran that wishes he didn't listen to that advice. So the veteran had a kidney condition, a renal dysfunction condition that resulted from his exposure to certain chemicals while he was in the military. In other words, he was exposed to chemicals, he started having renal problems because of it, or kidney problems. He also had a claim in for hepatitis C that at the time would not have given him much more in terms of an impairment rating. When you get 100% for one condition and then get another 10% for Hep C on top of it, it's not going to add anything monetarily to your claim in most situations. But when he got the 100% rating for the renal condition, he withdrew the Hep C claim. And that's not an uncommon scenario. I've talked about it a couple times in this video. VSOs will encourage veterans to withdraw claims or appeals in order to get that TDIU 100% rating. It's called horse trading, and I think it's wrong, but it happens an awful lot. So in this veteran situation, years later, he was diagnosed with liver cancer. He thought it might be related to his hepatitis C. His doctors agreed with him. They said that the reason that you have this liver cancer is because of chronic hepatitis C. That's a fairly common scenario. That's probably one of the, if I remember correctly, hepatitis C is one of the leading causes for liver cancer in certain age groups of men and women. But the veteran in the story that I'm telling you spent the last 6 months of his life trying to get Hep C service connected so he could show that the liver cancer was secondary to that hepatitis C. So during a time in his life when the veteran could have used the extra special monthly comp he would have gotten for having two 100% disabling conditions, the renal condition at 100% and liver cancer at 100%, he would have gotten that statutory special monthly compensation, that SMCS I told you about earlier, would have given him about another $400 or so a month. It would have made his final days a lot more comfortable for himself and his family, but instead he was battling a VA bureaucracy that just could not move quick enough. Here's the takeaway point. If you believe a condition is service-connected, in other words, you have a medical condition, you believe that it's related to your military service, continue to pursue that service connection, even if it's only going to give you a 10% or even a 0%, a non-compensable rating today. Because tomorrow, a year from now, 5 years from now, or 10 years from now, it might be the key to showing that another condition, one that is far more serious, is service-connected. I want to tell you this gets into some complex theories of service connection, and there are really 5 paths to service connection of any medical condition, and you should assert as many of those 5 as you can in each and every claim. I have an ebook out there which teaches you the 5 paths to service connection. It's called the Service Connection Field Manual. You can see this link on the screen here now. Click on that link. You can see what's covered in that book, and you can find out where to download your own copy. So, you've reached 100%. You're thinking about giving up the fight with the VA because you're at 100%. Here's the 6th scenario that I want you to think about before you give up the fight. And I want you to think about your surviving spouse or your surviving dependent children, or in language that I really, really, really hate, the VA still calls children who are over the age of, I think it's 18 or 21, that cannot earn an income. They call them helpless adult children. I hate that term. That's another story for another day. But I want you to think about those 3 folks, because let me tell you the story. I have an axe to grind when it comes to the VA and surviving spouses. When my grandfather died from an injury that he sustained at the Battle of the Bulge in World War II, the VA told my grandmother there's nothing they can do to help her or her 5 kids. They were flat out wrong. They could have helped and changed the entire course of her life, and frankly of her children's lives, of my aunts and uncles. In the course of representing a lot of surviving spouses, I see that same scenario play out time and time and time again. Let me tell you what that scenario is. Veteran dies from a medical condition. Medical condition was related to his or her service in the military. The veteran gave up the claim for service connection of a condition because he reached 100% on another condition. So now, if the veteran dies from a service-connected condition, the one that was 100%, the surviving spouse is entitled to a benefit called Dependency and Indemnity Compensation, or DIC. It's a monthly benefit. It's misleadingly called service connection of the cause of death. But if the veteran did not prove that a condition that he had or she had was service connected during his or her lifetime, the spouse is going to get another chance to prove that it should have been service connected. So a veteran's failure to pursue service connection for one condition, the one that ultimately caused them to pass away, does not prevent the survivor from recovering. But it does make that survivor's claim or appeal really hard for the surviving spouse. Many times, you're the sole breadwinner for your family. When you pass away, your spouse is left to fend for him or herself, often with children still to raise. Most surviving spouses, whether it's by the grace of God, the support of family or friends, most surviving spouses find a way to eke out a living after their veteran husband or veteran wife passes away. But if their spouse had kept up the fight with the VA while they were living, it wouldn't have had to be so hard. The spouse might have had the ability to grieve the loss without having to find replacement income by battling the VA on an accrued benefits claim or a DIC claim. The spouse might have had a lot of more time to spend honoring the veteran service, more time grieving, time healing, Instead, they spend years fighting the VA to win a benefit that they could have had really quickly if the veteran had continued to pursue the claim while living. So think about this. You reach 100% service-connected disability on condition A. If there's any possibility that conditions B, C, D, E, or whatever other conditions you're claiming service connection for could bring about your death, consider whether you should continue pursuing those claims, because if they are service-connected and they lead to your death, in some situations, most situations, the surviving spouse is going to be able to get what used to be called a widow's pension, or now is called DIC, because of that. So think about your surviving spouse, keep fighting the fight, or consider continuing to fight the fight. I don't want to suggest that you have to. I don't want to put any kind of pressure. I just want to give you the scenarios that you might want to consider continuing the fight once you get a 100% rating. So these are not the only 6 scenarios that a veteran should follow or continue fighting service connection after 100% rating. There's a lot more out there, a lot more scenarios or situations. The best guidance that I can give you is don't pursue a rating percentage as your goal. Instead, set your goal on service connecting every medical condition or disability that you believe relates to your military service. When everything is service connected, once all the ratings are properly assigned and all the effective dates are properly chosen, that's when I say the veteran should stop fighting for the VA benefits that they're entitled to. Not when they reach 100%, or not when they get to 100% service connected conditions, or not when they get all the past due benefits on 1 or 2 conditions. When you get to a point where all of the medical conditions that you think are related to your military service are service connected, when you get to a point where all those conditions have the proper impairment rating and all of them have the proper effective date, that's when I think is the smart time when you could say it's time to stop fighting the VA. So hopefully this has helped you out. I know that this is a lot of information. That's one of the reasons I did it as a video post, so that you could pause the video, come back and relook it from time to time. This video will be posted on the hadit.com site. I'll also keep it on the veteranslawblog.org site for our premium content members. And it may be available for a short time on YouTube. But in any event, if you have any questions, feel free to hop on the hadit.com message boards and ask other veterans there for their experience with these types of situations, or you can pop over to the veteranslawblog.org, and there's a form you can fill out there to contact me and ask any questions you might have. In any event, thank you again to the folks at hadit.com. Good luck with your VA claim or appeal. Let me know if there's any questions that I can answer for you.